Ever wonder who you can sue when a truck crashes into you?
I mean, usually the driver, right? Maybe the company that owns the truck?
Sure. But what about the broker? The company that matched the trucking company with the shipment in the first place?
Okay, I need you to back up. What's a broker?
You didn't listen to our interview with Mark Blueball? We broke it down there. He wrote an amicus brief for the Transportation Intermediaries Association, an amicus brief that Justice Kavanaugh cited at oral argument.
Oh, yeah, now I remember. He explained that brokers operate as matchmakers for the shipping industry. You've got a company that needs to move 1,000 plastic pots from point A to point B. The broker finds a trucking company willing to haul those pots. They connect the dots. About 28,000 brokers operate in the U.S. right now, arranging roughly a third of all freight shipments.
Good save. Everyone, check out the episode. I'll link it in the show notes. That's a massive industry. It highlights the enormous stakes involved here, right? And the question today, can you sue the broker when the trucker they hired causes a catastrophic crash? I feel like the answer should be obvious.
Well, the 7th and 11th Circuits said no, the 6th and 9th Circuits said yes, and now the Supreme Court just weighed in.
Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, we're breaking down Montgomery versus Caribe Transport. The court ruled 9-0 that states can impose negligent hiring claims against transportation brokers who select unsafe trucking companies. Justice Barrett wrote the majority. Justice Kavanaugh filed a concurrence, joined by Justice Alito. This decision affects every broker in America and everyone who's ever shared the road with a commercial truck.
Which means everyone.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scottis.cases.pod@gmail.com.
Here's what you need to know. So, Sean Montgomery drove a tractor trailer for a living. March 2020, he pulled over on the side of a highway in Illinois. Stopped, engine off, just sitting there on the shoulder. And then Yosniel Varela Moyena, driving a Mack truck loaded with plastic pots, veered off course and slammed into Montgomery's truck. Doctors had to amputate Montgomery's leg. He sustained other severe and permanent injuries, life-altering crash. Varela Moyena drove for Caribe Transport, a motor carrier. But here's the key detail. C.H. Robinson. Worldwide, a broker had arranged the shipment. Montgomery sued everyone: the driver, the trucking company, the broker, and every corporate entity connected to them. And the claim against the broker specifically alleged negligent hiring, meaning Montgomery argued that C.H. Robinson knew, or should have known, that hiring Caribe Transport to haul goods created a reasonably likely risk of crashes.
What made Montgomery think C.H. Robinson should have known?
Caribe Transport carried a conditional safety rating from the Federal Motor Carrier Safety Administration.
Which means what?
Federal regulators found Caribe Transport deficient in driver qualification, hours of service compliance, inspection procedures, maintenance standards, and recordable crash rates.
So a bunch of red flags.
Huge red flags. Montgomery claims C.H. Robinson saw those flags and hired Caribe anyway.
And then the federal courts threw out Montgomery's claim. The district court held that a federal law called the Federal Aviation Administration Authorization Act.
Wait, aviation? We're talking about trucks.
I know, terrible name. The FAAAA preempts state laws related to prices, routes, and services in the trucking industry.
So, Congress wanted to stop states from regulating trucking companies economically.
Exactly. The law dates back to 1994. Congress wanted to deregulate the industry, eliminate state barriers to interstate commerce, encourage competition.
But Congress also included a safety exception.
Right? The law says the preemption provision shall not restrict the safety regulatory authority of a state with respect to motor vehicles.
So states can still regulate safety.
That's the question. Does a negligent hiring claim against a broker qualify as safety regulation with respect to motor vehicles? The district court said no. Following 7th Circuit precedent, the 7th Circuit affirmed they ruled the safety exception doesn't cover brokers.
Why not?
Their reasoning went like this. Brokers don't own trucks. They don't hire drivers. They just arrange shipments. So claims against brokers don't really concern motor vehicles.
But the 6th and 9th Circuits disagreed. They held that negligent hiring claims against brokers fall squarely within the safety exception because selecting an unsafe carrier directly affects which trucks end up on the highway.
Circuit split, Supreme Court grants cert. Oral arguments happened March 4th, 2026. Decision came down May 14th, 2026.
9-0 for Montgomery. Unanimous reversal. Justice Barrett wrote for the court.
All right, walk me through the court's reasoning.
The court started with something everyone agreed on. Common law duties and standards of care count as part of a state's authority to regulate safety.
Makes sense. States have always used tort law to regulate dangerous conduct.
Negligent hiring claims specifically impose a duty of reasonable care when you employ a contractor for work carrying a risk of physical harm. That comes straight from the Restatement of Torts.
So the real question became whether negligent hiring claims count as regulations with respect to motor vehicles. And the statute doesn't define with respect to, which means the court gives it its ordinary meaning. Barrett looked at dictionary definitions. With respect to means referring to, concerning, or regarding.
Okay, but how does that apply here?
The court already interpreted the same phrase the same way in a 2013 case called Dan's City Used Cars versus Pelkey. There, the court said, with respect to means concerns.
So a claim falls within the safety exception if it concerns motor vehicles.
Right? And the statute defines motor vehicle as a vehicle, machine, tractor, trailer, or semi-trailer, propelled or drawn by mechanical power and used on a highway in transportation.
Trucks. Putting it together, a claim qualifies as with respect to motor vehicles if it concerns the vehicles used in transportation. And requiring a broker to exercise care when selecting a carrier concerns the trucks that will haul the goods.
Exactly. The court said it most obviously concerns the trucks that will transport the goods. Montgomery's negligent hiring claim falls within the safety exception.
That seems straightforward. The broker raised 3 counter-arguments. C.H. Robinson argued that Montgomery's interpretation swallows the preemption provision whole. If every claim related to broker services also qualifies for the safety exception, the preemption clause does nothing.
How did Barrett respond?
She said no. The safety exception saves only a subset of preempted claims, those involving regulations concerning motor vehicle safety. Plenty of state laws related to broker prices, routes, and services have zero relationship to safety.
Give me an example.
A state law capping how much a broker can charge. That's a price regulation, preempted, no safety exception.
Because it doesn't concern motor vehicles.
Correct. Or a state law dictating which highways a carrier must use for economic reasons. Route regulation, preempted, no safety exception.
Second argument?
Surplusage. The statute separately preserves state authority to impose route controls based on vehicle size, weight, or hazardous cargo. C.H. Robinson argued that if Montgomery's interpretation prevailed, those carve-outs become redundant because they also address safety.
What did Barrett say?
The surplusage exists regardless of how you define with respect to motor vehicles, because the overlap comes from the word safety, not from the disputed phrase, and the provisions harmonize anyway. States might impose route controls or weight limits for reasons other than safety, like preventing highway wear and tear.
Third argument?
This one involves subsection B of the statute. Subsection B preempts state regulation of intrastate rates, routes, or services of brokers. Unlike subsection C, subsection B doesn't contain a safety exception.
Wait, so states can regulate broker safety for interstate shipments but not intrastate shipments?
That's the anomaly C.H. Robinson flagged. They argued it makes no sense for Congress to allow state tort suits against brokers for interstate trips while blocking state tort suits for intrastate trips.
How did Barrett handle that?
She granted it sounds weird, but she said it would sound even weirder to conclude that the negligent hiring of an unsafe carrier whose truck caused injury doesn't count as the safety regulatory authority of a state with respect to motor vehicles.
So she applied the text.
The text of subsection C controls. Better to live with the mystery than to rewrite the statute, and that's how you get a 9-0 decision.
Well, Justice Kavanaugh wrote separately to say this case presented closer questions than the majority opinion suggested.
But he still concurred.
He did. He just wanted to flag some concerns.
Like what?
First, the statute requires minimum insurance coverage for trucking companies, but not for brokers. Kavanaugh said that dichotomy suggests Congress didn't anticipate tort suits against brokers. Otherwise, Congress would have required brokers to carry insurance too.
That's a fair point.
Second, the interstate anomaly we just discussed, Kavanaugh called it exactly backwards from ordinary preemption doctrine.
So why did he still vote with the majority?
2 reasons. First, the overall structure of the law. Congress pursued economic deregulation, not safety deregulation. The statute doesn't preempt tort suits against trucking companies, and the negligent hiring tort against brokers serves the same purpose, keeping unsafe trucks and drivers off highways.
What's the second reason?
Federal law imposes almost no safety-related regulation on brokers. The regulatory agency requires brokers to select federally registered carriers, but doesn't impose safety standards on broker hiring.
So brokers operate in a regulatory black hole.
That's what concerned Kavanaugh. He found it doubtful that Congress would allow brokers to operate with zero meaningful safety oversight through oblique language in an economic deregulation statute, especially when truck safety involves life and death. He cited the numbers. In 2022, about 500,000 truck accidents resulted in roughly 5,000 deaths and 114,000 injuries.
Wait, seriously?
That's the data. Kavanaugh emphasized that some accidents can get prevented, some carriers operate less safely, some drivers present unfit risks.
Did he
Address broker defenses? He stressed that brokers won't routinely face liability. Brokers who act reasonably and arrange transportation with reputable companies should successfully defend tort suits.
What counts as reasonable?
Kavanaugh quoted plaintiffs' counsel from oral arguments. Brokers just need to hire carriers that maintain reasonable policies and ask hard questions of carriers, and proximate cause requirements should help.
Exactly. State tort law requires showing the broker's negligence actually caused the crash. That's a high bar.
But Kavanaugh acknowledged broker concerns. He noted that state tort law can prove unpredictable. Litigation and insurance costs may prove significant even when brokers win, and those costs cascade through the economy to consumers via higher prices.
Did he say that changes his analysis?
No. He said the concerns carry weight, but don't carry the day. And he closed by noting that brokers can ask Congress to change the law if the practical consequences prove problematic.
Which brings us to what this actually means.
So what actually changes after this decision?
Every transportation broker in America now faces potential state tort liability for negligent hiring. That's 28,000 companies arranging about a third of all domestic freight.
And plaintiffs injured in truck accidents can pursue not just the driver and trucking company, but also the broker who matched them with the shipment. What does that mean for broker operations? Brokers now carry incentive to investigate carrier safety records before arranging shipments. That means checking federal safety ratings, crash histories, maintenance records, driver qualification.
Does the decision specify what level of investigation counts as reasonable?
No, that's one of the open questions. Courts will have to determine what conduct constitutes negligent hiring on a case-by-case basis. What about other types of claims?
Also open, the court didn't address whether the safety exception saves other claims against brokers beyond negligent hiring. And we've got this weird intrastate-interstate asymmetry. States can impose tort liability on brokers for interstate transportation, but not intrastate transportation.
That could incentivize brokers to structure operations around interstate arrangements where possible.
Or it invites a constitutional challenge to subsection B. The court noted at oral argument that questions exist about Congress's authority to preempt state regulation of purely intrastate activity. The court explicitly declined to address it because subsection B didn't come before them.
So that fight might return. Kavanaugh's concurrence also functions as an invitation to Congress. He outlined legitimate broker concerns about unpredictable tort liability, litigation costs, insurance expenses, and economic impacts. Then he noted that brokers can ask Congress and the president to change federal law. Bottom line time. Why does this case matter?
Because it defines who bears responsibility when unsafe trucks cause crashes. Before this decision, 4 circuits blocked injured parties from pursuing brokers who knowingly hired dangerous carriers. Now, states can enforce accountability up the supply chain. And that creates market incentives for brokers to prioritize safety over cost.
If holding costs for hiring cheap, unsafe carriers, brokers will shift toward carriers with strong safety records,
Which should reduce crashes.
That's the theory. Kavanaugh noted that not all accidents can get prevented, but some can. This ruling targets the preventable ones,
And for anyone who shares the road with commercial trucks.
which means literally everyone.
This decision makes those roads marginally safer by ensuring brokers can't play matchmaker with dangerous carriers without consequences.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. Because nothing says Monday morning like debating the scope of FAAAA preemption provisions. Talk to you soon.